Your name?
George Jones the fourth.
Okay, what do you have as his balance?
With cost 2752.16.
2752.16. All right. My note here, and I don't know how real it is, because I is this one? This one? No, here. The green one. Okay, not that one. Okay. It's somebody else. All right. It just says client and landlord submitted all necessary documents. Client's application has been submitted to the funding source for approval. Should have an update on approval no later than 5/12. That's what the paper says.
She sent me an email saying on the 5th, Jenna Pillow over at SOS sent me an email on the 5th saying that everything's in process. They're going to update to let you guys know that that funding should be imminent.
Okay. Up to the 12th, wait for the update. If everything get paid, let's get it paid.
The 12th is
Huh?
12th is Tuesday.
No, I was sure. See.
Oh, okay. Can that be on Zoom? I do start a new job.
Then get to submit a Zoom request, sir.
Okay. Yeah, I start a new job on Monday.
May 15th, 2026 at 3 p.m.
Okay.
Let's see if they'll get it paid, because I think after this month it all disappears. Are you gonna get this paid?
I get paid on the 25th. I'll pay it in full.
You'll pay it in full on what?
25th of this month.
25th? Okay, then here's what I'm gonna do. I'm gonna find no tribal issue after hearing. That total amount, I'm sorry, council, was 10,007
$700.25.
dollars and 25 cents. All right, I'm no tribal issue after hearing. I'm going to issue a judgment for possession, redemption amount in that amount. I'm going to set a calling back for next basic aid. It would be the 18th. You said you could pay by
25th of this month.
25th. All right, so I'll extend out his date a week to May 25th, 2026. All right. Okay, thank you. Soil Farms versus Janelle Baker. And yeah, can you get me into Zoom on my thing so that I can go into a break?
Last one.
Last one. Your name?
Baker.
Oh,
Well, thank you.
all right. How much does plaintiff have owing?
With the May charges, Your Honor, well, let me say this. Ms. Baker did make her May rental payment, but there would be a $55 late fee. With that, it's at $3,042.47. But Ms. Baker did receive approval through Hawk for $2,985.45, which is the balance less that late fee.
Got it. Okay. You follow that?
Yeah, so where's my balance at? I didn't.
It's what, $55 she needs to pay?
Yeah, it's $55 over and above what Hawk approved her for. It may be $57, Your Honor. When Hawk looked at her ledger, it had the court costs in at $190, but they're actually $192. So I think the difference between what Hawk is paying on her behalf and what's currently due is $57.
57, okay.
All right. You think you can get that into them?
Right now, immediately, yeah.
Okay, because the other balance, I think, is
My credit card right now.
okay. All right. Then why don't I do this? Since that payment is coming in, you're going to get that payment in. I'm just going to adjourn it out a week to the 15th at 3 p.m. You won't need to be here if everything's paid.
Okay.
Okay. So what I'm hoping is that the check gets to them, you get the other monies in, you're at a zero, and then the case gets dismissed.
Yeah, they said it might take a couple weeks for the funds to get to Sile Farms.
When did they tell you that?
I got an email because I was following up on with Hawk earlier in the week, and they sent me an email with
The verification.
the verification, right?
What I do
Of-
instead of the 15th, I'm going to go to the 22nd
Okay.
at 12 noon. It's no harm, but we'll let the check get there and hopefully we can just
Yeah.
okay.
Yes. Thank you. And
Thank-
so if those funds are dispersed and I pay that 57, I don't have to show up.
Don't have to show up because you'll be at his.
That is
well, no,
the same. Thank you, Your Honor.
you're welcome. Take care.
And the May late fee, Your Honor, $2,815.85. Similarly, Your Honor, Mr. Moore did get approval from Hawk. His assistance is for $2,758.85. It's a difference of $57. The late fee and then the $2 court cost difference.
57. All right. You gonna have $57? Okay, great. All right. This for me then. I'm gonna do the same thing I just did on another 2 weeks. Yeah, I'll put
Okay.
out to May 22nd, 2026 at 12 noon. Pay the 57. We'll wait for the check to get in. If everything's at 0, I don't need to see you on that day. All set. All right, sir? Yep. Yeah. You take, all right. What are we doing on this case?
Your Honor, I believe that Ms. Musa and Mr. Ibrahim have filed amended or new pleadings. My understanding is that what was previously filed was struck by the court as it didn't comply with the court rule. I'm not entirely convinced that what was refiled complies with the court rule. There have been some changes to it, but there are still several sections of the pleadings that still don't comply with the applicable court rules. I would argue, I suggest that these pleadings were AI generated and not appropriately revised to comply with the Michigan court rules. And so I would argue that they should be struck yet again. But I would defer to the court in that regard.
What do you have to say to that?
Your Honor, 90% of those pleadings is exhibits.
Pardon?
Exhibits. 90% of it is just documents.
Yeah, but it's got to be presented in the proper fashion,
Right.
and they're not.
The answer to non-payment of rent. That's correctly.
How much is owing?
Your Honor, this isn't an action for non-payment of rent. This is an action for termination of tenancy. A 30-day notice to quit was issued as defendant. Ms. Musa is a month-to-month tenant.
And we've been month to month since the beginning, or at least
All right, but what's your defense to the termination?
the, we had a housing inspection on Monday, actually, because of a mold issue from February that we asked them to fix properly.
So
Uh,
let's assume all of that's correct. Why should you be permitted to stay in the premises?
well, the city came to us and told us that this unit doesn't have a valid certificate of occupancy. We don't actually want to.
Okay, if it doesn't have a valid, you're going to leave then? When you going?
Exactly. I don't plan on
When are you going?
by the end of the month.
By when?
Month.
A case for possession only. They don't want you there. You say you're leaving. So
Well, yeah, we have no problem with the possession case. It's more of a I paid $45,000 in rent over 3 years, and first of all, the lease don't have a valid certificate, and the unit has been moldy the entire
try to
time.
get your pleadings in order on that because that's not really properly raised before the court.
What was the issue with the answer to non-rent?
Have you gotten a lawyer on this? Because I'm not here to give legal advice.
No, we're not. We don't have a lawyer on.
They did not. Did you pay to sue them for a money judgment?
Say again? Did I pay them?
Yeah, you're trying to sue for a money judgment.
Did I pay the court, you're saying?
Yeah.
No, they told me there's no fee for that to file the papers.
All right.
Your Honor, if I may just add for
Go ahead.
just to be specific with respect to the issues that I have with the pleadings, Your Honor, there's 2 different answers filed. One is an answer to a non-payment of rent case, which doesn't apply here. The second is an answer civil, which would apply for a general civil case. This isn't a general civil case, summary proceedings case. So there is no proper answer filed. There's a
That's-
document filed called an order for change of venue, which appears to be a request to transfer the case to the Washington County Circuit Court, but that's not a venue issue. Would be a
Correct.
removal request based on allegations that, based off of this, I believe his allegations are that his alleged damages exceed the jurisdictional limit of the district court.
But I don't have an affidavit on the claims.
And Your Honor, there is a document filed that's called affidavit in support of petition of change of venue. The problem with this alleged affidavit, and in reality, Your Honor, it is a regurgitation of the alleged counterclaim, number one.
Right.
But number two, it's not an affidavit because it's not been signed in the presence of a notary. So it doesn't constitute an affidavit. And so this so-called order for change of venue doesn't apply either. With respect to the counterclaim, again, Your Honor, as was indicated at the last court date, even though some changes have been made, the bulk of this counterclaim still does not comply with the applicable court rules. And so for those reasons, I'd ask that the court again strike all of these documents as improper. Again, I would also, as the court indicated, this is an action for possession. Defendants are, well, defendant Ms. Musa and Mr. Ibrahim, who I believe is an unauthorized occupant in the unit, are in agreement with vacating. And so I don't have any authority to grant additional time beyond the 10-day time frame. So I would have to ask for a judgment requiring possession on or before May 18th. But again, I would defer to the court with respect to that.
But why would you say that I'm not an authorized occupant of the unit when I've been paying you guys since the beginning of the lease? I have emails with the management, with the property manager, everyone that works there, addressing me by name. I pay you. My mom has never paid anything to Spice Street Apartments. Why would you say I'm an unauthorized occupant?
Well, it really doesn't matter whether you're an unauthorized occupant or not, quite frankly, because the pleadings and documents that are filed are not in order. They're not in compliance with the court rule. There isn't even an issue regarding venue in this case. That's not the terminology that would be used. To the extent I were to even construe it as a motion for removal, doesn't have a proper affidavit attached. It doesn't have an affidavit, as far as I'm concerned, attached to it, so it's not filed in compliance with the court rule. I'm going to order once again that the documents are stricken as they are not filed in compliance with the Michigan court rules. I am then finding also that, given the statements of the defendants, that there's no tribal issue on a termination case in this matter. I'm going to grant a judgment for possession to the plaintiff for possession. There's no redemption amount. A writ would issue in 10 days.
No. Carla?
Pardon?
2 weeks?
Pardon?
2 weeks on the Rick?
18th.
It is.
You'll have to deal with the landlord if you want additional time, but it's 18.
And I have no problem giving the property back. If they're not going to fix it, I don't want to live in a moldy unit. Is there no issue, even if with all the documents being struck, is there no issue with them renting me a property that is not compliant with the city?
There may be an issue,
Right.
but you have to file the proper paper. I'm not going to make your claim here. You have to do it properly.
Okay.
So if you don't know how to do it, get a lawyer.
Can you give us time to do that? We got this summer.
Sir, you filed the additional pleadings. I had to strike them.
Okay.
Then you redid it. I had to strike them again. I'm not going to waste my time waiting for you to get it right.
I'm asking for time.
If you wish this court to do something else, get a lawyer. They can file a motion with this court to do something else. But at this point, I am not. The judgment that I've issued just now will stand. Thank you.
And Your Honor, I would just also point out that to the extent that they feel they have a claim against my client, it does not have to be brought in conjunction with this case. I would disagree that they have a claim, but that doesn't change the possession issue. So
That's right.
So,
Yes, ma'am.
can I ask question? Can I move my name because this is
She doesn't live here.
this is his problem. I live somewhere else.
You live someplace else.
Yeah.
I know, and that's what we were told. The problem is you're still on the lease. I can't remove your name.
The tenants continue to argue that they're authorized occupants and that the property has mold, but the judge has had enough. He strikes the documents for a second time and grants the landlord a judgment for possession. The tenants have 10 days to vacate. The judge tells them that if they want to pursue claims about the mold or the certificate of occupancy, they need to do it properly, with a lawyer and in the right court. One tenant tries to argue that the case shouldn't apply to him because he doesn't live there, but the judge points out he's still on the lease. This case is a cautionary tale about the importance of proper legal procedure. You can have the best defense in the world, but if you don't file it correctly, it won't matter. The judge showed patience, but even he has limits. If you found this case as wild as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.